I'm Ron Morton, certified elder law attorney. We get a lot of questions about living trusts. What is a living trust? What's the difference in a living trust and other types of trusts? What's the deal with probate? These are all questions that we frequently get, and I wanted to address some of those in today's installment. A living trust is, in its simplest form, a separate entity that you create yourself. It's an entity that you get to define exactly what it does, how it works, and ultimately who controls it. A trust is simply a contract between two individuals. The grantor of the trust, sometimes you'll hear them called the settlor, or sometimes you'll hear them called the trust maker. That's all the same person. That's the person that actually drafts the trust instrument and puts in the controlling language as to how that trust will operate. The other individual that's a party to a trust agreement is the trustee. Now, the trustee is the person that actually manages the trust assets for the benefit of the beneficiary. And so a trust in its simplest form is simply a device that is designed to benefit the beneficiary pursuant to its terms under the control of a trustee and created by the grantor. I like to use the analogy of swimming. Let's say that I'm out at the beach and I am about to go for a swim, but I don't want to get my money wet. And so if I handed you my money and said, hey, will you hold on to this for me for the next half hour or so while I go swimming, and you agreed to do that, then I could go and swim without worrying about my money being lost or stolen or getting wet. And when I was done, I could simply return and ask you for my money back. Upon my return, then you would no doubt return my money to me, and I could then spend it as I saw fit for the rest of the day. That, in its simplest form, is a trust. By handing you the money, I was the grantor of the trust, or I was the trust maker of the trust. By agreeing to accept the money and hold it for my benefit, you became a trustee of the trust. And so as trustee, you were managing that money, albeit for a short period of time on the beach, but nonetheless, the money was under your control, under your management. And you were managing it for the benefit of me. So I was also the beneficiary of the trust. Now, every trust has those three positions: a grantor, a trustee, and a beneficiary. There's nothing that says, however, that each of those positions have to be held by different people. And so in my example on the beach, I was both the grantor of the trust and the beneficiary of the trust, but I had a third-party trustee in this example of you. But there's nothing that says that the grantor of the trust can't also be the trustee of the trust. And that, in its simplest form, is what a living trust is. An inter vivos revocable trust is what's commonly referred to as a revocable living trust, or simply a living trust. And what that refers to is individuals that will create a trust instrument and define how it is that their assets will be managed. They'll appoint themselves as the manager of the assets, the trustee. They will appoint themselves as the beneficiary of the trust. And as the grantor, they would also be the grantor of the trust. They would be the ones drafting the trust instrument. And so then what they're able to do is take their assets and transfer the title of those assets into their trust. The title then would no longer be in their name. It would be in the name of the trust and be managed by them for them. So very similar to what they would be doing now, but instead of being owned by them, it would be owned by the trust. The benefit of this is twofold. One, when that individual dies, the trust does not die. The trust is an entity that still exists, and the trustee merely changes. And so you would name in the trust an alternate trustee as to who would manage the assets if you no longer could. The beneficiary of the trust would also change by definition, because at your death you would no longer need the benefit of a trust instrument. And so the trustee changes, the beneficiary changes, but the trust is still very much alive. What this results in is anything owned by the trust does not need to go through the probate process. Probate is designed to transfer title of assets from dead people to living people. If a trust owns the assets, then the trust doesn't die, and so there's no reason to go through the probate process. The trust merely changes by its own terms. It changes who the beneficiary is and changes who the trustee is. Now, I mentioned that there were two big advantages to the trust. The first is probate avoidance. The second big advantage of the trust is control of assets in the event of incapacity. I mentioned successor trustees that might be named at the point of death. You could also name successor trustees in the event that you became incapacitated. The benefit of this is that in the event of an incapacity, an individual would simply have a second trustee being able to step in and manage their assets for the benefit of the beneficiary, without having to go through through a conservatorship, without having to go through any kind of legal requirements in order to pass control over those assets. And so that's the twofold advantage of a living trust versus simply holding assets in your own name and having them pass through the probate process at death. There is a catch, I guess that there always is, and that is the trust only controls those assets that have been transferred into it. And so if you create a living trust but don't fund the trust, that is, you don't transfer title of your assets into the trust instrument, then it is not that does not control those assets. Those assets are still owned by you, and the only way to transfer those assets to the next generation is going to be to go through the probate process. So it's imperative, if you create a revocable living trust, that you also fund the revocable living trust. And what that means is, for bank accounts, change the name of the bank account from being in your name into the name of the trust. For real property, change the title of the property from your name into the name of the revocable living trust. If you do those things, and then as you acquire new things, that you put those also in the name of the revocable living trust, then at your death, there will be no need to go through the probate process. A new trustee simply steps in and follows your instructions as to how to manage those assets for the people that you name as beneficiaries, as substitute beneficiaries at your death. I'm Ron Morton, certified elder law attorney. If we can help, please give us a call. Thanks.